So I keep having this reoccurring dream where my Civ Pro professor shows up to class in his PJs. I don't know. I think I need some serious R&R. I think law school is finally starting to get to me, but you know what? Speaking of PJs, let's talk about personal jurisdiction. My man, Big Steve. Perfect timing, man. Listen, since you brought your cameras to class, let's take a snapshot of the big picture of PJ for our barrister buddies. Here's the big picture. If someone sues you, there's one thing better than winning the case. That's right, having the case dismissed. In your Civ Pro class and on the exam, you've got to remember that PJ is usually used as a tool to dismiss a case or kick it out. It's really simple. The plaintiff sues the defendant, and then the defendant asks the judge to kick the case out because it does not have proper personal jurisdiction or proper PJ. In Civ Pro, we call it a 12b2 motion to dismiss for lack of personal jurisdiction. How you like them apples? So imagine you're 5. Your classmate Susan accuses you of stealing her lunch money. The next day, some random kid serves you with a yellow Post-it note from Susan's overprotective mom that says you have to show up at Susan's house for a hearing on whether you stole her lunch money. Even at the ripe old age of 5, of course you're thinking, wait a minute, this is creepy. Susan's parents can't haul me into their living room. They don't have any jurisdiction over me. Immediately, your kindergarten 1L instincts kicks in and you file a 12b2 motion to dismiss the case for lack of personal jurisdiction. Now, on one hand, this example is very silly, but when analyzing a personal jurisdiction fact pattern, our role is to make arguments on both sides of how it is or is not fair or reasonable that a defendant, like an alleged 5-year-old lunch thief, be subject to the authority or jurisdiction of an out-of-state court, in this case, Susan's mom's living room. Like Susan, the plaintiff wants the case heard in the court that she filed the lawsuit in. The defendant, on the other hand, would rather not be in the court of the plaintiff's choice. Do you guys know what makes me so cool? Exactly. Let me show you guys how to build a super cool understanding of personal jurisdiction by giving you the framework for analyzing a case in your casebook or a fact pattern on an exam. The first step is to consider what's called the constitutional framework of personal jurisdiction. You see, when a plaintiff files a case in a court, the court is considered the forum court. If the forum state or the forum court is going to have jurisdiction over a defendant that lives in a different state, then the forum court is going to have to satisfy the requirements of the Constitution. I call this the constitutional framework. The specific constitutional standard that must be met is the Due Process Clause of the 14th Amendment. The Due Process Clause essentially requires that a court be fair and reasonable when it reaches out of state to hear a case involving an out-of-state party. There are 3 types of jurisdictions that must meet the Due Process Clause of the Constitution. They're called in personam, in rem, and quasi in rem. In personam is when the basis of the forum court's authority or jurisdiction over the defendant is because the defendant is present or lives or has a representative or agent in the forum state. In rem is when the basis of the forum court's authority or jurisdiction over the defendant is because the defendant owns property in the forum state, and that property is the basis or the reason why the plaintiff is suing the defendant. Quasi in rem is when the basis of the forum court's authority or jurisdiction over the defendant is because the defendant owns property in the forum state, but the thing is that property is not the basis or the reason for the plaintiff's lawsuit against the defendant. The basis of the lawsuit is something else altogether, but the property is used as a means to tie the defendant to that forum state. Together, these 3 bases are considered the traditional bases for jurisdiction. The second step is to consider what's called the statutory framework for personal jurisdiction. The statutory framework must still meet the requirements of the Constitution's Due Process Clause. This step uses what's called the long-arm statute. You see, in modern times, the way that a forum court reaches into another state to bring an out-of-state defendant into its courtroom for litigation with the plaintiff is by the use of the state's long-arm statute, or long-arm law. I like to picture an imaginary arm stretching from one state into another to grab a defendant and bring her into the plaintiff's forum state. Pay close attention in class because some professors like for students to be able to analyze whether the specific language of the long-arm statute is in fact constitutional or falls short. Step 3. Once you've spotted the issue of the long-arm statute, now you have to apply what's called the International Shoe Test. The elements of the International Shoe Test are the Supreme Court's way of giving us guidance on how to argue or determine whether a long-arm statute meets the Due Process Clause of the 14th Amendment's standard of being fair and reasonable. In other words, by analyzing both sides of the factors of fair and reasonableness, we can determine whether using the long-arm statute to bring an out-of-state defendant under the jurisdiction of a court in another state is in fact constitutional. If not, then the case will have to be dismissed for lack of personal jurisdiction. But the first factor is the minimum contacts test. Under the minimum contacts test, you're analyzing whether the out-of-state defendant has had sufficient contacts with the forum state to justify bringing the out-of-state defendant under the forum state's jurisdiction. Depending on the facts and circumstances, you'll consider arguments within the minimum contacts test such as purposeful availment, stream of commerce, and foreseeability. No worries, we'll get a better idea of these specific arguments soon. The next factor is to consider whether litigating the suit in the forum court would offend what's called fair play and substantial justice. This is more of a balancing test between the burden of litigation on the defendant versus the interest of the forum state and other important policy considerations. Analysis of the minimum contacts test and fair play and substantial justice give us all the information we need to determine whether there were enough contacts to give the forum court either general jurisdiction or whether the contacts were so few that the forum court may only assert specific jurisdiction. The difference between general and specific jurisdiction is that if a defendant has a lot of contact with the forum state, then a plaintiff can sue an out-of-state defendant in the forum state even on a claim that is unrelated to the things that a defendant did or the contacts a defendant made while inside the forum state. However, if a defendant had few contacts with the forum state or less involvement with the forum state, then the plaintiff is limited to suing the defendant only on matters related to the defendant's conduct in the forum or what the defendant did while in the forum. Essentially, a plaintiff's lawsuit can be a lot broader when the circumstances allow for general jurisdiction, but the scope of a plaintiff's suit is a lot more narrow if the circumstances only allow for specific jurisdiction. Now that you have a copy of my super cool DNA framework, let's get out of the classroom and get funky. You see, the best way to get a solid understanding of how the rules of personal jurisdiction work is to analyze them in context of examples. This is exactly what happens in class when we talk about cases, and what's supposed to happen on an exam when you answer the fact pattern or exam question. At the Law Academy, we call this the ABCs. Let's see here. Here's a cool fact pattern. Before Martha was a hotshot attorney, she was an anxiety-ridden 1L at Bull Hall. After a violent altercation with a few of her study group members, the dean of students suggested that Martha take up a hobby to help alleviate her severe case of Gunner syndrome. Martha took up painting. Her vivid images seemed to move in a manner reminiscent of the great artists of the Impressionist movement. Over her 1L summer, Martha was inspired to incorporate in Delaware and launch a website from which she sold her art. In a short time, she had developed a small but devoted following in New York, as critics sympathized with the torture the artist must have felt as a law student. Martha hired a few salespeople in New York who solicited orders for her in New York and sent the orders to Martha's headquarters in Berkeley for approval. Later, the art would be shipped to the buyer FOB, that is, at the receiver's expense. The New York salespeople earned handsome commissions for their sales, grossing over $200,000 over a 2-year span. However, the great state of New York brought action against Martha in New York for failing to contribute to the state's unemployment compensation fund. Martha makes a 12b2 motion to dismiss the claim for lack of personal jurisdiction. Let's knock this out of the park with some super cool analysis. The first thing we're going to do is briefly state that in order for the New York court to establish personal jurisdiction over a California resident, the court's reach must be fair and reasonable under the Due Process Clause of the 14th Amendment. Next, we're going to examine whether New York's long-arm statute satisfies the minimum contacts and fairness test first established by the Supreme Court in International Shoe. Turning to minimum contacts, we will argue that Martha Incorporated contacts with the forum state of New York were continuous and systematic because the activities continued to take place over a period of several years, and the sales activities generated considerable business profits and consisted of a network of sales agents in the state of New York. Still under the minimum contacts analysis, we will counter-argue that Martha Incorporated's contacts are insufficient because Martha's contact was not continuous and systematic, but irregular and casual. She'll argue that she was never present in the state. Neither did she own property in the state, and the salesman only placed orders while the actual sales contracts were made at the California headquarters in Berkeley. Heck, technically, Martha didn't even ship her art into New York because shipping was paid for by the buyer, FOB. Making these arguments on both sides earns you points on the exam, but for practical purposes, side with New York on this issue, just as the Supreme Court did when faced with similar facts in a case called International Shoe. Remember, however, that conclusions are far less important than analysis. As I always tell my private clients, it's not about answers, it's all about analysis. Now that you've argued both sides of minimum contacts, it's time for an analysis of fairness. One argument is that finding that Martha Incorporated had minimum contacts in New York does not offend traditional notions of fair play and substantial justice because just as Martha may have the burden of being sued in New York based on her contacts, she also has tons of benefits and protections that would enforce her rights if she got into a lawsuit in New York. Other arguments would be that the forum state of New York has an interest in protecting its tax base, as well as the plaintiffs. New York's interest in convenient and effective relief is also important. As you can tell, the fairness factors lean in favor of the forum state, New York. With both minimum contacts and fairness under our belt, we move on to argue general versus specific jurisdiction. Now that we know whether the defendant's Martha's activities in the forum state qualify as sufficient minimum contacts, the question is whether the plaintiff's claim, New York's claim, arises from or relates to Martha's activity in the forum state. If it relates, then New York has a broader general jurisdiction and can sue Martha for a claim that arose anywhere in the world. If P's claim is unrelated or does not arise from Martha's activity in the forum state, then New York has a more narrowed specific jurisdiction and can only sue Martha for things that she actually did in the state. Applying the rules of law to our facts, the result is somewhat of a gray area. You see, there's a strong argument that Martha Incorporated had continuous and systematic contact with New York, which weighs in favor of general jurisdiction. However, there's also a strong argument that New York's claim for taxes is unrelated to Martha's activity in the New York forum. Were the claim based on a tort or contract lawsuit involving Martha's art or the orders made in New York, then the relatedness would be a lot stronger. Because this is a gray area, it is at the court's discretion to treat as general jurisdiction or specific jurisdiction. Of course, you'll make arguments on both sides and rake in the points. The conclusion? The court is likely to deny Martha's 12b2 motion to dismiss for lack of personal jurisdiction. New York wins, baby. Okay, Max, you got it. We'll do another one. Let's try this on for size. Martha's legal woes didn't stop in New York. A neoconservative Texan, Pete, who heard of Martha's work while passing through Berkeley, purchased a piece which he hung prominently in his sprawling Austin, Texas ranch-style vacation home above the fire mantle. Martha was pleasantly surprised by the sale because she neither advertised or solicited business in Texas and had never sold or distributed her art in that arid part of the nation. As it turned out, the oil used in this particular piece was defective and highly flammable and resulted in a rather spoiled Christmas Eve when the entire ranch home went up in a blaze, causing significant personal and property injuries to the Austin family. The family has launched a suit against Martha in Texas. Martha wants the case kicked out and moves for a 12B2 motion to dismiss for lack of personal jurisdiction. Let's analyze it. Of course, the first thing we're going to do is briefly state that in order for the Texas court to establish personal jurisdiction over a California resident, the court's reach must be fair and reasonable under the Due Process Clause of the 14th Amendment. Next, we're going to examine whether the Texas long-arm statute satisfies the minimum contacts and fairness test first established by the Supreme Court in, you guessed it, International Shoe. Let's make minimum contact arguments. We'll lead with the stronger arguments. For starters, there is no action, neither continuous or systematic or irregular or casual, that Martha took to make contact with the state of Texas. In fact, it was Pete, not Martha, that unilaterally made the contact with Texas by taking Martha's art there. Also, Martha did not purposefully avail herself of the privileges of doing business in Texas, since she neither solicited nor sought business in the state. Even though Martha does operate a website that is accessible by any state in the union, this isn't enough, since Martha's website does not target any particular state, including Texas. Let's take a shot at the counter arguments for minimum contacts, because we've got to make counter arguments to rack up points. The Austin family might argue that while Martha did not purposefully avail herself, it was in fact foreseeable that her art could be purchased by a resident of any state in the union. Heck, she has a website. In a creative way to argue for purposeful availment, the Austins may also contend that since Martha purposefully placed her goods or art in the stream of commerce, that is, on the internet, she knew that her art could ultimately come in contact with any state, including Texas. But without other and more direct contact with the forum state of Texas, such as advertising, the Supreme Court has found arguments like this to be weak under the circumstances presented. After a Texas-sized analysis of minimum contacts, it's time to make arguments under the fairness factors. Well, not so fast, you barrister bandits. We actually don't make fairness factor arguments here because there isn't a minimum contact to rest our jurisdictional hat on. Remember that in order to move to the fairness step, you need at least one minimum contact under the present facts, and we just don't have one. But what does that mean for the general versus specific jurisdiction analysis? Well, without minimum contacts, there is no jurisdiction at all. As you can see, failing to establish any minimum contacts results in the forum state having no personal jurisdiction over the defendant. The conclusion? The court is likely to order Martha's 12B2 motions, or to grant Martha's 12B2 motion to dismiss the Austin's claim for lack of personal jurisdiction. Go Martha, go Martha. Okay, that's enough of that. You like this, don't you? Well, if you insist, and only if you insist, I'll do one more, but only one more. By this time, Martha Incorporated has gone public. But aside from unimaginable wealth, 3L year was a year of love for Martha. After falling head over heels for her business association adjunct professor, Professor McDreamy, Martha was inspired to franchise an art gallery with a snowbird art collector in Florida. After lengthy negotiations, Martha and Mr. Whopper entered into a franchise agreement for a 20-year period with payments made to Martha's California headquarters on a quarterly basis. Martha's CFO in Florida would oversee the franchise. The franchise agreement also included a choice of law provision that called for California law to govern the contract between the parties. Mr. Whopper loved Florida and never traveled to California for business or pleasure. After a year, Mr. Whopper began to fall behind on his payments, and Martha brought an action against him in California. Under 12b-2, Mr. Whopper moves that the court dismiss Martha's action for lack of personal jurisdiction. So, my friends, what's the analysis? Well, first things first. We're going to briefly state that in order for the California court to establish personal jurisdiction over a Florida resident, the court's reach must be fair and reasonable under the Due Process Clause of the 14th Amendment. Next, we're going to examine whether the California long-arm statute satisfies the minimum contacts and fairness test first established by, yes, the Supreme Court in International Shoe. Now let's make those minimum contact arguments. We'll lead with the stronger arguments. There were several actions taken which suggest that Mr. Whopper purposefully availed himself of California law. First off, he engaged in lengthy negotiations for a $1 million contract and for a 20-year period with a corporation he knew to be headquartered in the forum state of California. The contract was also performed in the forum state of California, since quarterly payments were sent to Martha's headquarters in, you guessed it, California. Additionally, Mr. Whopper availed himself of California law by agreeing to the choice of law provision, which subjected the franchise agreement to California law. These factors also support arguments for foreseeability, since a reasonable person who negotiated to the terms that Mr. Whopper negotiated, who made payments and agreed to the choice of law provision in California, that reasonable person would know that any dispute would likely be litigated in a California forum. Mr. Whopper will counter-argue that he reasonably believed that his contacts were limited to Florida and Florida only because he only did business in Florida and never once traveled to California. He will also raise the point that his business operations were overseen not by California, but by a Florida-based member of Martha's management team. Now, with minimum contacts arguments done, let's take a crack at the fairness arguments. Mr. Whopper will argue that it would be difficult or inconvenient for his witnesses to make the great voyage to the West Coast from Florida. He'll also argue that his burden is too high because Martha has far more economic resources than he. These arguments will likely fail because they do not meet the constitutional magnitude for inconvenience. The court is looking for situations where the burden on the defendant is gravely difficult or there is a severe disadvantage. Putting witnesses on a flight from Florida to California is not gravely difficult, and the court is reluctant to dismiss a case for lack of jurisdiction because a party is more wealthy than another, unless there are compelling reasons. Otherwise, a party could commercially benefit from a business contract in a forum only to have the case dismissed because one party is more successful in business than another. In other words, don't hate me because I'm loaded. So there they are, both minimum contacts and fairness arguments. But what about the type of jurisdiction? Is it general? Is it specific? Well, that all depends where Mr. Whopper's activities fall along the spectrum between mere irregular and casual contact with the forum versus continuous and systematic contact with the California forum. Based on the minimum contacts analysis, Mr. Whopper's activities are definitely more continuous and systematic than they are casual and irregular. So what's left is to figure out whether Mr. Whopper's activities are related or unrelated to Martha's claim. Apparently, Mr. Whopper's activities, negotiating and paying the franchise agreement, and the claim that he failed to make the agreed upon payments are directly related. So, it looks like the California court has general personal jurisdiction over the claim. In other words, Whopper has had enough contacts with the state of California that he could be sued by a California resident for activities that took place in the state, even though he was never physically present in the state. The conclusion? The court is likely to deny Whopper's 12b-2 motion to dismiss Martha's claim for lack of personal jurisdiction. Go, Martha. It's your birthday. Okay. I just get excited. So, my law school professor did not show up to class in PJs. But I have been noticing that a lot of my classmates seem to be wearing their PJs to school.